Senator Sinclair. So Ms. Douglas will take note of these. I'd like to welcome members to this meeting. Our last meeting, of course, was October 19 last year. And as you are aware, we're continuing the review by statutory requirement that the Integrity Commission Act, established 2017, should be reviewed from time to time, but within a 5-year period. And that 5-year period would have expired on the 18th of February 2023. The commencement, however, of the review would be in line with the statutory requirement as we started to review from last year. And already we have had submissions from the Integrity Commission, the FID, NIA, Jamaica for Justice, BESS 100 FM, Morning Connection, the Jamaica Accountability Portal, that's JAMP, Jamaica, I think, LAMS. In addition to those who made oral presentations, we also had submissions from Norman Manley Law School, Permanent Secretaries Board, and the PSOJ, who asked the committee to rely, of course, on their written submissions. Team, just to refresh ourselves in my opening remarks, that according to Section 3, the principal object of the Integrity Commission, of course, Act R 1, further encourage and promote propriety and integrity among persons exercising public functions in Jamaica. B, to promote and strengthen measures for the prevention, detection, investigation, and prosecution of acts of corruption. C, to ensure that government contracts are awarded, varied, renewed, or terminated impartially on merit and in a financially prudent manner. And finally, to enhance public confidence that acts of corruption and impropriety committed by persons exercising public function will be appropriately investigated and dealt with in a manner which achieves transparency, accountability, and fairness. So it is required pursuant to Section 60 that a review of the acts take place from time to time. And that should be done by a committee consisting of members from both houses of Parliament constituted for that specific purpose. And that's the basis on which this Joint Select Committee continues to meet. The first such review must be conducted, as I said, within 5 years after February 2018, which is the appointed date of the Act. This is with the exception of Section 42(3)(b), which must be reviewed within 2 years of the appointed day. I think we did that already ahead of this particular committee. Section 42 may be reviewed in its entirety within 2 years. If the review is in relation to the publication of summary statutory declarations, then that follows. So any review of Section 42(3)(b) or 42 must be conducted by a committee consisting of members of both houses of Parliament constituted for that purpose. This is primarily the legal framework that gives authority to what we are doing. I know that we have gone a long way with the number of submissions that have come in already, team. So today, we really wanted to look at how we proceed here from. If there are any further presentations that we can accept, but to prepare a timetable to wrap up the review overall and to make appropriate recommendations for amendments as may be necessary.
Chair, thank you. I recall at the last meeting, almost at the conclusion, that a member had asked if there was another entity that was required to make a submission, whether the committee could consider it. I think you indicated then that if it was received, it would be circulated to the members and a decision taken. Has one been sent in?
Absolutely. Absolutely, member, because we haven't actually closed the review. it continues. So I will take any other comment on the basis of my opening remark, and if not, we can move to the reading and confirmation of the minutes. Yes, so we can go, because there is an opportunity for discussion.
Afterwards?
Yes, afterwards, yes. So can we have the minutes? They have been presented and are before you. Do I have a confirmation? Yes, confirmed by Member Robinson, seconded by Member Guy. Matters arising. Any critical matter that any member wishes to raise? There being none, shall we move then to the discussions? And the first, of course, is procedural matters. And I indicated that what we want to do now, and to be guided by the committee, is the next steps. As Member Guy indicated, that there was another submission that some entity wanted to present, we can offer that opportunity. And if there are any other...
But was that submission circulated or told?
No, we're not taking it, no.
I know,
we're
but
just accepting that. It wasn't received. It wasn't received.
But Member Guy, is it possible, is there any way we can communicate to that person to just submit it? Who?
Member Hamilton, who had made that request.
You mean
yes.
Tova?
Yes.
Yes.
So we just ask her to, and she's a member of the committee? Fine. So we just, I would say we just ask her to submit it, like Member Warmington has also submitted something today.
So we will take these submissions. We will take these submissions in the normal course of...
Sure.
Yes. So I wanted to indicate, however, that there is a need for us to complete the review, and that we want to establish a time frame over the next few weeks that we can conclude the discussions. But certainly we want to open the opportunity for any further submissions that may wish to come at this time. There has to be a closing time anyway, after which no more submissions.
I thought we have closed off.
No. We remember the question was asked at the last meeting, and I think we had responded favorably to looking at... Yes. So I'm allowing for further submissions.
Right.
Yes.
But what I'm thinking, though, to the best of my knowledge, we will have all the submissions. One of the things we should have been asked is for the secretary to probably do a matrix for us. The matrix is available.
Yes.
So I would suggest if the matrix is available, we adjust it in light of the two
Correct.
submissions.
Correct.
And I would say, Chairman, that we should discuss if we could do a 1-day or 2-day retreat to just go through the matrix and make decisions. Whatever.
No, but I mean, in fact, what we need to do, as I think all members are, is to get a sort of a summary of the critical points that were made in the presentations, the areas that we want to consider, and then we could deliberate on them over perhaps a weekend or maybe over a 2-week period, as the case might be, and then to make our final decision. But I think a matrix was... Yes, it's there. Yes. It's here.
It was sent out as well.
Right. It was sent out. It's a little thick, as you will notice, right?
And circulated. You have it,
Yes.
with the notice.
Okay, so we consider then, team, that today's meeting, we would like to agree on a time period for the report. May? Minister Chuck, see you.
I'm suggesting,
you're contemplating the timeline.
I was hoping, Chairman, that we could really do it before and have any changes to be made before the end of the term. If we do it in May, we may not be able to.
The term is not possible again. That's the 31st of March. So
No, please. I mean, by the end of July.
Oh.
You know, because, the truth of the matter.
But May would be in good line, I think. I'm being guided, team, because I know all of us are busy people, and we have.
I know what difficult, but the
so.
timetable, though, Chairman, we need this to make whatever changes and whatever, improvement or restriction on this Integrity Commission at an early date. And the reason why I'm saying so, when I look at the budget, I notice in the budget it has been increased to 1.2 billion. And I think this committee has a duty to give this Integrity Commission some guidance as how they move forward, okay? And to the extent that we can have fulsome discussion, because I know there's this great call, for opening it up and what have you. I mean, my position is very clear. We're not doing any opening up, but they must have a regular update to Parliament, how many investigations they're doing, and the state of how many they've closed off. We need a regular update from the Integrity Commission so we know that the 1.2 billion at least is not being sat on, that they're actually working. In addition, Chairman, the Protective Disclosure Act should also be updated at the same time.
Correct.
Because I have no difficulty promoting the Protective Disclosure Act, and to the extent that we call it the Whistleblower Act, we let them use as much of this money as possible to encourage people to expose corruption at any level that people see it, so that it can be investigated, because far too many things appear to be corruption when it is nothing but sus. So, let it be known that people have the opportunity. If you know that there's corruption, expose it or shut up. Right? So I would say after this meeting, Chairman, we should also look at another quick meeting to do the protective disclosure so that we can do both and conclude as soon as possible.
I would say the May deadline is realistic. I see Member Warmington has a number of proposals which have to be considered, and even though we are here representing the opposition, a number of these things require consultation within our own parties. So, and there are far-reaching recommendations. So I would go with May, as it gives us enough time to have that consultation to come back here with definitive positions.
Sorry, are we saying the end of May? In other words, the objective is to complete all our deliberations and to have the report ready for the Parliament by the end of May.
I would
31st
agree
of
with
May. May, 31st of May.
We're at the end of March already, Delroy.
But we can't do it until we meet in May.
No, man. We're talking our timeline to complete our work. I'm not interested in anything but, at the moment, focusing on completing, because we've started this review from early last year. And I think the public is expecting that we would. And to your point, Member Chuck, that the feeling mustn't be that we are being anything but active and strong in enabling the solutions to some of the issues that have been burning out there and the concerns that some of our players have had. So I'm given to now look at a schedule of meetings between now and the 31st of May that will achieve our objective. So the discussion will move into that direction. To your point, perhaps a retreat. I know, no. I'm trying to be procedural here, to make sure. Yes. But I favor, a quick completion of our deliberations. So let's suggest there is a sort of, the problem is we run into the Easter season within the next week or so, and then you have the, So I'm quite prepared. I'm prepared to meet whenever the committee thinks that the time is.
But you're talking about a retreat when?
In April.
In April?
Yes.
No, but I thought you were talking about giving enough time.
No, but if we do in April, the submission, for example, that Minister Warmington has put on the table, members will have time to think on it, to look at it, and to be able to make their own
so you'd
determination as to...
You'd like to have 1 or 2 more meetings before the retreat?
Absolutely.
And you're saying the retreat could be sometime in May?
No. I'm saying the report should be ready by the 31st of May.
Oh.
Now, I don't want to put the retreat down into the month of May. I want to have a retreat in April that allows us to have now enough time after we have even deliberated and concluded to review again, if needs be, among ourselves before we make the final report.
All right, no problem.
Okay, so let's look at a possible time in April. I would say to the back end of April, because we start another activity somewhere else on the 18th. So I would say, member Robinson, I didn't hear you. Right, so let's look, Ms. Douglas, look at the weekend after the 18th. That would be the 21st, 22nd? No, the 18th is Tuesday. So that weekend now would be the 23rd or something like that. Am I correct? 22nd is the Saturday?
That's April.
Yes, April. So let's do 2 days, Friday, Saturday?
Senate meets. You have senators on the committee, Chairman.
Yes, I know that one. So we couldn't do it that weekend because we don't want that happening. So the following weekend, 29th, 30th of April.
Sunday, Saturday, Sunday, or Friday, Saturday?
Friday, Saturday. So 28, 29. So we agree on that. To 28 and 29. Pardon?
Senate meets, Chairman.
28 is out for me, Chair.
Plus the Senate might.
So team, let's agree to Saturday, the 29th. Because the Senate is probably going to meet, or no, I don't think so, because the Senate doesn't meet when we're having sectoral debate. And sectoral will be going on. Remember, you only deal with legislation that come to you. So when you have, some urgency. All right. So let's agree on the 29th of April. 29th of April, that it will be. Okay, so team, the review of the Act, as I said, is before us. Today we are not going to deliberate on the details of this. We will reserve our final deliberation for the 29th of April. But I want to recognize the submission from Member Warmington and perhaps ask him to make a comment on it.
I'm laying my recommendation and addendum to it. So can I be given the opportunity to make my presentation as other persons who have made submission to this committee? Thank you very much, Chairman. Chairman, I begin by saying, and I'm making a submission in my capacity as a member of Parliament from Southwest St. Catherine, or the member of Parliament from Southwest St. Catherine. And first I said the Integrity Commission Act, or the Act, was passed into law in 2017. Its stated objects and purpose is to promote and enhance ethical standard of conduct of parliamentarians, public officials, and other persons, and to establish a single body, the Integrity Commission, or the Commission. The Commission's role and function, responsibilities and duties are to A, investigate allegations of complaints relating to acts of corruption, and B, prosecute persons where there is supporting evidence. For the Commission as a single body to be effective, the Act repealed, replaced, and/or amended the following pieces of legislation: the Standing Orders of the House of Representatives, the Parliamentary Integrity of Members Act, the Corruption Prevention Act, the Contractor General's Act. The Act, together with the foregoing statutory provisions, created the legislative scheme to deal with acts of corruption, which is defined by the Act as an offense relating to the conduct of any person that constitutes an abuse or misuse of office, whether or not within the public sector, for the purpose of conferring a benefit or advantage for himself or any or another person, being an offense arising under common law or any enactment. Through the recognizing the dynamic and fluid nature of the subject matter, and that the Commission was now in its infancy, Parliament deliberately inserted provision to keep the legislative scheme under periodic review by both houses of Parliament. Accordingly, Section 60, subsection 1 of the Act provides as follows: the Act shall be reviewed from time to time by a committee of both houses of Parliament appointed for that purpose. This submission to review the Act and the current practices and procedures of the Commission is presented pursuant to and for the purposes of fulfilling that mandatory review requirement of the Act. The nature, role, and function of the Commission. The Integrity Commission is a commission of Parliament. See Section 5, subsection 1. This means it falls under and is subject to the direction of Parliament. Therefore, the Commission is subject to the oversight of Parliament, and for that purpose, the standing orders have been amended to establish the Integrity Commission Oversight Committee, as one of the select committee of the House under the standing orders. The role and function of the Oversight Committee is set out at Standing Order 77D of the Standing Orders. 5, I brought this to the attention of the members to remind us of the context and the legislative framework against which we are embarking on this review process. The legislative framework and the Act in particular makes it clear that the Commission is not a law unto itself, not an unbridled horse, as some may want it to be. As a committee of this Honourable House, it must, and at all times, carry out the objects and purposes of the legislative scheme against corruption scrupulously and with no motive other than fulfilling the clear and ambiguous provisions of the legislative scheme, which comes from the policy position taken by Parliament. This committee, therefore, in its deliberation, must constantly bear in mind that we function under a constitutional democracy, and therefore we should be constantly mindful of the provisions of the Constitution, particularly in instances where its provisions are raised as concern and the tendency of the Commission to overreach. Consideration of the Review Committee. As a committee, we are obliged to take into account and consider any concerns coming from the Integrity Commission Oversight Committee. The reason is that the Oversight Committee is charged with responsibility of monitoring and reviewing the performance of the functions of the Commission, reporting to both houses on any matter relating to the performance of the functions of the Commission, and assessing the effectiveness and appropriateness of its procedures. It is against the foregoing background that this submission is being presented to the Review Committee for consideration of the recommendation for amendment to the Act. Proposed amendment to the Act. Amendment 1, composition of the Commission, removal of the Auditor General as a member. Then this is section 8, subsection 1, subsection A. In reviewing the composition of the Commission, I have come to the view, supported by legal research, that the inclusion of the Auditor General as a member of the Commission may be unconstitutional. The inclusion of the Office of Auditor General as a member of the Commission compromises the constitutional role, function, and duties of the Auditor General as set out in sections 120, 121, and 122 of the Constitution and the Financial Administration and Audit Act. The role and function, duties and responsibilities of the Auditor General are spelled out in Part 4 of the Financial Administration and Audit Act. The Constitution and Financial Administration and Audit Act make it abundantly clear that the role of the Auditor General is to audit all organs and bodies of the state, and is constitutionally required to present the audit reports to Parliament. It is inconsistent with the foregoing constitutional provision, and indeed would compromise the office of the Auditor General in the performance of the duties and the carrying out of the office's responsibility for the person occupying that constitutional position to sit on, be an integral part of, and participating in the deliberations of a body which the Auditor General is required by the Constitution to audit. Furthermore, the Auditor General is constitutionally required to present the auditor reports to Parliament. It is clearly untenable for the Auditor General to carry out an audit of a committee of Parliament of which the Auditor General is a member. The foregoing interpretation of Section 122 of the Constitution is clearly correct, as subsection 4, subsection B of Section 122 states that the Auditor General is to be audited and reported on by the Minister of Finance. Recommendation. I'm recommending that Section 1, subsection A, appointing the Auditor General, to be deleted and replaced as Parliament deems appropriate, consistent with the object and purpose of the Act. The removal of the Auditor General from the Commission does no harm to the integrity of the Commission, as the Auditor General may at any time conduct an audit of the Commission's affairs. Furthermore, the Acts allow for the Commission to request reports and to enlist the cooperation from all organs of the state. See Section 7. Amendment 2, and this has to do with statutory declaration of members of the Commission. Section 64. Section 64 states that the Commission may make regulations prescribing the procedure and manner for filing of statutory declaration by the Commission, directors and staff of the Commission. There is no question that members of the Commission be members of a select committee of Parliament, as specifically stated in the standing orders, are public officials. Accordingly, Part 5 of the Act, statutory declaration, applies to the members of the Commission and makes filing mandatory. Therefore, in the interests of transparency and accountability, and to avoid any issue of preferential treatment of the Commission and its staff, it is proposed that the same provision for preparation and filing of statutory declaration required by the Act be made fully applicable to the Commission and staff, except that the filing of these declarations are to be gazetted. Recommendation: amend Part 5, Section 39 to say that in the case of the members of the Commission and staff, statutory declarations are to be gazetted. Amendment 3, insertion of Section 20 of the Contractor General Act. The Contractor General Act, the Parliament Integrity Act, Members Act, and the Corruption Prevention Act, together with the Act, create the legislative scheme designed to identify, prevent, and where found, root out corruption. Part of these pieces of legislation were repealed and replaced in the Act or left in place where the entire law was not repealed, as in the case of the Integrity Members Act. In the case of the Contractor General Act, a number of the provisions were repealed and reinserted in the Act except Section 20, which deals with procedure after investigation, which provides as follows. 20 subsection 1, after conducting an investigation under this Act, a Contractor General shall in writing inform the principal officer of the public body concerned and the minister having responsibility therefore of the result of that investigation and make such recommendation as he considers necessary in respect of the matter which was investigated. 20 and section 2, subsection 2, if any report of a Contractor General reflects adversely upon any person, the Contractor General shall, so far as practicable, inform the person of the substance of the report. There are similar provisions to be found in Financial Administration Act governing investigations by the Auditor General. The wisdom of the inclusion of this provision in the Contractor General Act, which was clearly omitted by the oversight in the Integrity Commission Act, is based on our constitutional guarantee requirement for fairness in legal proceedings, particularly where those proceedings may lead to adverse consequences for the person under investigation. Where there's a negative or adverse finding against a person governed by the Act, that person ought to have an opportunity to comment and respond to the report before it is sent to Parliament. Further, the response of the person against whom the adverse finding is made should accompany the Commission's finding when it is being submitted to Parliament. Furthermore, there has been no credible reason given to Parliament for the omission of this provision in the Act, the value of which caused its inclusion in the Contractor General Act in the first place. The submission is for an appropriate amendment to be made to the Act to include a provision to capture the foregoing reasoning. Amendment for Director of Corruption Prevention, Prosecution, Section 34, to return this role to the DPP. Section 34 creates the position of Director of Corruption Prosecution, whose duty and function are the prosecution of crimes committed under the Act, including the crime of act of corruption. However, the section expressly states that the Director of Corruption Prosecution is subject to Section 94 of the Constitution. Section 94 vests the Director of Public Prosecution full power and authority to institute and undertake criminal proceedings against any person. Furthermore, subsection 4 expressly states that the DPP is empowered to authorize any person or authority to exercise the prosecutorial powers vested in the office of the DPP. Based on the foregoing, Section 34 of the Act is either unconstitutional without an amendment to Section 94, or it is alternatively, no prosecution can be lawfully carried out by the Director of Corruption Prosecution without the permission of the DPP, first had and received, oftentimes referred to as fiat. Another basis we support this amendment derives from the fact that the Commission is a committee of Parliament. This means that the Commission is subject to the standing orders, the rules governing the conduct of parliamentary business. It would have the effect of Parliament setting up its own investigating arm which proceeds to criminally prosecute a special category of persons. This is inconsistent with our constitutional arrangement where crimes are investigated by one arm of the state, the police, and prosecuted by another, the DPP. That Parliament should establish a committee of Parliament which has power to carry out criminal prosecution is inconsistent with a democratic form of constitutional government. I am buttressed in this view by the statement of the Honourable Chief Justice of Jamaica. In January this year, on the occasion that His Lordship addressed the Jamaica Constabulary training seminar on the new firearm law, he questioned the soundness of the model of the appointment of special prosecutors under the example of the Integrity Commission Act, outside the constitutional role of the DPP. These have never been successful. Having regard to the foregoing, Mr. Chairman, the following amendment is proposed. The provision of the Act which vests prosecutional powers in the Commission should be deleted as those powers are constitutionally vested in the DPP. Practice, procedures, and operation of the Commission. The Integrity Commission is called upon to A, receive statutory declarations, B, review or investigate income, assets, and liabilities. The procedures for the carrying out of the object of the Act are clearly and ambiguously set out in the Act, and its schedule and regulations are appended thereto. Nowhere in the Act or any of the companion legislation or the legislative framework governing the objects of the Act are created exceptions to the constitutional rights of parliamentarians, including the presumption of innocence and trespass to the person. I raise this in light of the recent report from the Commission for an amendment to the Act giving it power to exercise the discretion to make public its intention or that a matter person is under investigation or that an investigation has commenced. Such a practice would be inconsistent with the object and purpose of the Act, which specifically states that the Commission is, 1, to investigate allegations of complaints relating to acts of corruption, and 2, prosecute persons where there is supporting evidence. Accordingly, there should be no need and no justification for publication or announcements of an investigation until there is evidence warranting prosecution. Again, this evidence should be evaluated by the arm of the state, constitutionally empowered so to do, the Director of Public Prosecution, not by an arm of the Commission, whose administrative motive may be driven by consideration other than the strict objects and purpose of the Act. And even it is determined that there is evidence warranting prosecution, the constitutionally guaranteed presumption of innocence remains in place for all, no less members of the House and public officials. The Commission is called upon to consider and must bear in mind the irreparable damage that can be caused to the reputation of persons in public life and the far-reaching implications for their families and a premature announcement of allegation not yet proven in a court of law. Report from persons governed by the Act. I am aware of persons falling under the jurisdiction of the Act who are subject to certain practice of the Commission. These include the following: requests by the Commission for information and past statutory reports claiming that those declarations were incomplete. Declarants have reported that the Commission has requested declaration going back beyond the prior years, even more than 10 years. There seems to be no justification for requesting information on past declarations that have been filed in accordance with the law and accepted by the Commission. Recommendation: the Commission should not have any jurisdiction to carry out any proceedings under the Act before it was passed. And the Amendment 5 deletes subsection 2 of Section 63. Conclusion. This submission is consistent with the policy of Parliament as set out in the legislative framework. It is also in keeping with the efforts of well-thinking Jamaicans in trying to identify and root out corruption and corrupt practices, and also from my own experience of being a member of this House, that Honourable House, for more than 20 years. Our duty as a review committee established by the Act is to make it clear that policies remains that the prerogative of Parliament, the prerogative of Parliament who represent. Any attempt by the Commission in its practice and procedure to encroach on policy amounts to unwarranted overreach and must be rebuffed. The practice and procedures of the Commission must at all times accord the policy and to accord with the policy and to find the balance between enforcing the provisions of the Act while at the same time safeguarding the integrity of persons who choose public service and not a deterrent to persons who wish to serve. This, Mr. Chairman, I did in January. Since then, I have reasons to do an addendum. The behavior of the Commission and the Executive Director recently, where Jamaica was misled and where the Executive Director himself, dishonesty, we tweeted quotes that were out there and he knew that they were incorrect. Like from Reuters, the opposition made a statement, they were appalled, and that was based on the report that was laid in Parliament. The opposition was never aware of the ruling of the Director of Corruption Prosecution. Therefore, it's understandable that that statement was made. But then the Executive Director went and retweeted that, having known that he misled Jamaica and everyone, and stating that he was not obligated by law to lay that also. And having retweeted it, he caused the office of Executive Director to be called into disrepute. And I don't believe it's worthy of him to sit in that position based on that dishonesty. Then, Mr. Chairman, what I have here is that the recent submission of a report to Parliament by the Integral Commission and revelations following the statement of reports bring into sharp focus the current practices of the Commission, which again raise the question of whether they are motivated by consideration beyond the object, purpose, spirit, and intentment of the Act. This recent event makes it even more imperative for this review committee to give even broader consideration to the Act in general, but particularly to the following sections. 1, the immunity given to members of the Commission and staff, Section 55, must be amended so as to remove this immunity. B, the function of the Executive Director in developing and implementing operational policies and procedures in relation to the function of the Commission, Section 29, subsection B, subsection 5. C, reports of the Commission to Parliament, Section 36, and the second schedule. D, functions of the Director of Corruption Prosecution, Section 34, to be removed. See Amendment 4 of the main submission. E, findings of the Director of Investigation, Section 54. And F, commencements or assumption of investigation under all laws, Section 63. The Commission's report to the table in Parliament, February 14, 2023. The Commission tabled a report on February 14, 2023, in which it detailed matters concerning a company and which it alleges came under the influence of the Prime Minister. The report went on to say that 6 subsection 1 subsection 5, the matter concerning potential conflict of interest which arose in relation to the recommendation which was made by the Most Honorable Andrew Holness, is being referred to the Director of Corruption Prosecution for consideration. With respect to breaches of the Contractor General Act, the Public Sector Procurement Regulations 2008, the Corruption Prevention Act, and or any other applicable law. However, in a legal opinion dated January 12, 2023, the Director of Corruption Prosecution, having considered the findings of the Director of Investigation, ruled, in light of the foregoing, no charges are to be brought in respect of the allegations made. The ruling of the Director of Corruption Prosecution was neither included in the report of the Director of Investigation tabled by the Commission, nor was it included in the report tabled in Parliament on February 14th. Instead, the Commission issued a press release on January 4th and February 17th, which it stated interior. In the instant case, the report having been sent to the Director of Corruption Prosecution as required by law, she submitted a ruling dated 12 January 2023 to the Commission. The Commission, not having had the opportunity to read, this is a sick joke, understand and discuss it, took time to do so. 6, the report was sent to Parliament and was tabled on February 14, 2023. Confirmation of the table was communicated to the Commission on 15 February 2023. The Commission's review of the ruling having been finalized, instruction was given on the said February 15, 2023 for it to be published. And the publication was done on February 16, 2023. It is worth repeating and stressing that publication of a ruling could not be done before or simultaneously with the report. It had to await the tabling of report, that is the law as crafted by Parliament and referred to earlier. I think the Commission take everybody in Jamaica for fools when they come with this nonsense. We are well aware of the widespread publicity generated by the report, locally and internationally, and resulting political opprobrium suffered by the Prime Minister and the damage done to brand Jamaica. In the minds of all well-thinking persons, the Prime Minister has suffered a grave injustice at the hands of the Commission. The failure to include the ruling of the Director of Corruption Prosecution amounts to an act of misleading Parliament or gross negligence. Furthermore, the Commission failed to await the advice from the Director of Corruption Prosecution pursuant to Section 34, subsection 1, subsection B of the Act. This therefore raises questions of the motives of the commissions and the Executive Director in seeking to deflect from the true motives or as justification for failing to table the exculpatory ruling of the Director of Corruption Prosecution. The Commission states in its release that is the law as crafted by Parliament. We know must craft law that tell them this is how it must be. In that they're going to interpret it somewhere, we must write in a way that it can be misinterpreted. In other words, the commissions are saying that it followed the law as crafted by us in Parliament. As they interpret it. So it must be written away that the simple man will interpret it because them a big professor and what have you, and they want to twist it. That being the case, Section 60 of the law gives this review committee the authority to carry out this review. Accordingly, my strong recommendation is for a comprehensive review of the Act to remove areas of doubt and clarify uncertainty in parts of the legislation that could lead to events like the current situation or what took place in February, because it is in February. The sections referred to above are among the ones that should be subject to rigorous review. We may wish to consider the expansion of the membership of the review committee, as well as consider public hearings. After all, After all, prevention of corruption is everyone. After all, prevention of corruption is every Jamaican's business. Let us not be derailed by malicious intent. Further amendments. Amendment number 5. Part 6, Section 1, Privilege and Confidentiality, Section 55. Delete subsection 5, which reads as follows. For the purpose of the Defamation Act, any report made by the Commission under this Act and any fair and accurate comment thereon shall be deemed to be privileged. This must be removed. Amendment 6. Section 29, Function of the Executive Director. Among the functions, the Executive Director is responsible for developing and implementing operational policies and procedure in relation to the functions of the Commission. Section 29, subsection 1, subsection B, subsection 5. It is proposed that there be an amendment to this subsection requiring the Executive Director to submit the established practice and procedures to the Commission, which shall submit same to the Oversight Committee. This condition is consistent with the constitutional status of the Commission being a Commission of Parliament. Amendment 7. Reports of the Commission to Parliament, Section 36 and second schedule. Section 36(4). A report submitted to Parliament shall exclude matters that may, if included, prejudice proceedings in relation to any matter referred therein, and shall not contain any communication which is subject to legal professional privilege. Section 5, subsection 1 of the Act makes the Commission a commission accordingly. Its report to Parliament enjoy the privileges of Parliament. If that is the case, the Section 36, subsection 4 above, is of dubious validity and should be deleted. I recommend that we refer this to the Parliamentary Council for an opinion. Mr. Chairman, I think if I'm making a presentation, I think I should get your attention, and other members. It is only decent and respectful that I've given that.
Member, please.
All right.
You have my full attention.
All right, thank you. I take your word for it. Amendment 8. Amendment 8. Findings of the Director of Investigation, Section 54, subsection 1. Section 54 states that whereupon the completion of an investigation by the Director of Investigation is satisfied that there are reasonable grounds for suspecting that there is a breach of the Act or an act of corruption, Section 54, subsection 1, authorizes the Director of Investigation to submit his findings to the Commission through the Executive Director. The Director of Investigation is also required to submit the findings to the Director of Corruption Prevention, who may take such action as may be deemed appropriate. Amendment 54, subsection 1. On completion of an investigation, the Director of Investigation shall prepare and submit to the Commission through the Executive Director his finding and recommendation together with the ruling of the DPP, if any. The above amendment is not only appropriate but necessary based on the recent issue involving the Prime Minister. In my main submission, the recommendation is made to return the prosecutorial powers to DPP. Function of the Director of Corruption Prosecution, Section 34, to be removed. See Amendment 4 of main submission. Amendment 8, commencement of assumption of investigation under the whole law and before passing of the Act, Section 63, subsection 2. Subsection 2 of Section 63, which gives the Commission jurisdiction commence investigation in and prosecute matters prior to becoming into operation and going back on limited years, is to be deleted. The need for this amendment is obvious. Proposal for impeachment provision in the Act. The Act presently provides as follows. Read Commissioners. Part 3A of the Act deals with the establishment of a commission. Section 8 deals with the qualification for the appointment as a commissioner. And Section 9 states the persons who are disqualified for appointment. Section 15 deals with termination of appointment of commissioners. There are no provision in the Act for the removal from office of the Executive Director. Part 2B of the Act deals with the appointment and function of the Executive Director. Section 28, subsection 1 states as follows. Section 28, subsection 1, subject to the subsection 2 and 3, there shall be an Executive Director of the Commission who shall be appointed by the Governor General, acting on recommendation of the Commission. And Section 28, subsection 5 states, the Governor General may, acting on the recommendation of the Commission, terminate the appointment of the Executive Director for the inability of the Executive Director to discharge the function of his office, whether arising from infirmity of the body or mind, dereliction of duty, misbehavior, where he becomes an undischarged bankrupt, or is convicted of offense involving dishonesty or moral turpitude, or for any other cause. It is to be observed that in neither case, not in the case of the Commissioner, nor in the case of the Executive Director, there exists in the Act any provision for removal from office. Removal from office is different from termination of appointment. As presently drafted, the decision to terminate a Commissioner and the Executive Director rests with the Commission and the Governor General in the case of the Executive Director. And in the case of the Commissioners, termination rests with the Governor General. It is inconsistent with our constitutional structure for the Governor General to be acting solely on his own initiative. The constitutional construct is for the Governor General to act in council on or on the advice of the Prime Minister with the leader of the opposition, constitutional leader of opposition. This recommendation is to bring the Act in conformity with the Constitution, and therefore to add a provision for the removal from office of the Commissioners or any of the member and the Executive Director by impeachment provisions in the House of Parliament. This is on the basis that the Commission is a Commission of Parliament and subject to parliamentary oversight. Where the conduct of the Commissioners or any member or the Executive Director is determined to be demeaning to the office of the Commissioner or Executive Director, and which brings the office into dispute, and or where in the conduct of its duty and responsibility under the Act acts maliciously, recklessly, and or in callous disregard for the right of any public officer or parliamentarian. I'm asking for Amendment 9 to amend Section 15, subsection 2, subsection 3. C. The Governor General, acting upon a vote of impeachment of not less than 2/3 majority of both Houses of Parliament, shall remove from office the Executive Director, any other director, and all commissioners or any of them on the ground of misconduct in public offices. Mr. Chairman, these are my submission and proposal to Parliament. I don't think it is here for discussion today. We're all going to read through it and then come back here. That's what we decided before. So nobody get a chance to read through it yet, so don't comment on what I'm saying here. But you're supposed to read,
but
and we come back here to discuss it.
Member, I don't think you can presuppose the ruling and position of the chair.
No, that's what we
right.
agreed.
So I'm of the view that a presentation has been made. Members cannot be denied any comment that they wish to make on it.
I agree with that.
But in terms of the determination of this set of proposals, that will be reserved for our special meeting, which we have already set for the 29th of April. So the recommendations are before the committee, and it's being accepted in the form that we accept all other presentations that are made by witnesses that come before us, subject to comments from members.
Chair, I would just ask that I know that we don't have any representative from the chambers with us today, and maybe we didn't need one today, but I would think that when we come to looking at the matrix and we come to looking at the submissions, you know, I certainly have constitutional questions in my mind already that I would wish to be guided on, so just so that we can have that in place.
Point taken. Based on the fact that we are grounded in the Constitution of the country, and that's what guides us and determines our final action. So you're quite right, but then we will ensure that those particular support are with us for the 29th of April.
Thank you, Chairman. I was discussing with Member Golding how we continue to break new ground in the approach taken. I commend the member for the work done in bringing the presentation and the recommendations to the committee. I think it's probably a little unprecedented because it's not usually the case where a member of the committee. I'm saying that I commend the member for the work done. It's clear that a lot of work has gone into and a lot of thought has gone into the presentation he has made and on which we will have to deliberate. I was remarking to Member Golding that it seems as if we're breaking somewhat new ground. It's unusual for a member of the committee to make the kind of presentation, though we all, in response and in commenting on presentations to the committee, express our own views and outline positions that we take on matters. So for me, I'm still working my mind through the approach. We know that the review of the law is of high interest to all of us, not just committee members, but also members of the public. Member Golding indicated that a number of constitutional questions popped up. And as I was listening to the member in respect of some of the provisions, something in particular popped up. And I think there may just have been a little error in most of the statement of the law seem accurate. But on one point, I think there may be a little bit of, probably just a misunderstanding or an error. So Section 31, 1B of the Constitution does empower the Governor General to exercise his functions, any function that is expressed to be exercisable by him in his own discretion. As a general rule, the Governor General acts in accordance with the advice of the Cabinet or a minister acting under the general authority of the Cabinet. But there are exceptions created, and those exceptions include where the function is expressed to be exercisable in accordance with the recommendation or advice, or with the concurrence or after consultation with a person or authority other than the Cabinet. Classic example is the appointment of judges on the advice of the Judicial Service Commission, or on the advice of the Public Service Commission, or on the advice of the Prime Minister after consultation with the Leader of the Opposition. But there is another limb which empowers the Governor General to exercise his discretion to exercise a function in his own discretion. I think it may not be a well-known provision, but we do have, as we have gone into new areas and creating new institutions, for the very reason that the member has outlined, entrusted to the Governor General as head of state the power to act in accordance with Section 32, subsection 1, Clause B of the Constitution. But I think the bigger issue that I am hearing from the presentation is how we deal with commissions of parliament, and also the issue of what does it mean to be independent. Independent of whom? Because at the end of the day, everyone and every authority is answerable to someone. Well, even for the exception, the democratic arrangements are worth studying. They're worth studying because and we're all students and we learn a lot as we go along. But I'm amazed how many times I hear statements made with much force and would be accepted authoritatively, but are so wrong in law. Wrong in law and wrong in fact. And sometimes, you know, you can be mistaken and convincing, and you can be wrong and convincing. So I think as we embark on this review of this new structure, it may worth our while thinking about how the commissions of parliament work, and this one in particular, where we have gone ahead to amend the standing orders to create a specific oversight body to receive the recommendations, to do review of it. But my immediate point was just to point out what I think may be just a misunderstanding of the constitutional provision about the Governor General acting in his own discretion. It is permissible under the Constitution of Jamaica at Section 32, 1B.
Madam Hufort, I recognize Member Bunting.
Thank you, Mr. Chairman. I must say, this is my 5th term in Parliament, and it's one of the few times that I find myself supporting the member from Southwest St. Catherine. I mean, we're you know, usually we're usually more accustomed to exchanging some unparliamentary sort of comments across the aisle.
So much so that it's hard for you to get it out, Member Bunting.
So you wouldn't be uncomfortable a few days ago?
Well, you know, we'll comment on that in another forum. But I too, I mean, I don't necessarily agree with everything that Minister Warmington has said or has presented in his presentation and the addendum. But I too share a concern and share his concern over the quality of the reports and also the tendency, it seems to me, to sensationalize some of the findings. And, you know, if I use a personal example, Mr. Chairman, last year the Commission issued a report on these firearms licenses. And they criticized me as then minister. Granted, 2012, they were talking about some of the things I couldn't even remember the details. But they criticized me about 2 appeals that I reviewed and granted the licenses. But, and I am open to criticism. I'm fine. People can criticize you just like anyone else. But to deliberately omit from their report the fact that I was acting in accordance with the recommendation of the Firearm Review Board set up in the law to advise the minister. I mean, that is dishonest and unprofessional. This was a review board comprised of a distinguished panel of a former judge of the Court of Appeal, a former judge of the Supreme Court, and a leading Queen's Counsel. And they are the ones who have the hearing of the appeal, marshal all the evidence, and make a recommendation to the minister. In both cases, I acted either in accordance with their recommendation or more conservatively. All of that was omitted from their report to this Parliament, even though I had set it out in writing in response to their questions. Now, that is either just unprofessional, dishonest, or writing your report in a way to create, to sensationalize it. And so I am very concerned with the approach that they've been taking. I don't want to comment on some of the specifics that Minister Warmington has made, because specific recommendations, because I think it needs some further study and research on my part, having been hearing most of them for the first time. But I really think there is sufficient there now for the Commission to really have some reflection on the way that they've been operating. And I say this especially, the omission of the firearms, the role of the Firearms Review Board is inexcusable, in particular because the chairman of the Commission has also been the chairman of the Firearms Review Board. So he, more than anybody else, would be familiar with the role that it played in the law and in the Firearms Act. So, we really, we don't want to restrict, obviously, the role unnecessarily, but I think there is some degree of fairness and some natural justice considerations that was in the previous Contractor General's Act, where the responses of the persons who would be affected by the report were included. I think that has, that was a wise inclusion. I think that is worth reviewing in how we go on. And I really think the Integrity Commission needs to itself have some reflection on the way they have been going and on the agendas they have been pursuing, because I don't think it is helping their cause and their objectives, which we all support. But it sometimes is not, what you are pursuing, but how you are pursuing it, and the quality of the reports and the investigations that go into them. Thank you.
Thank you very much, Member Bunting. I recognize Member Chuck.
Chairman, I wasn't too sure whether this is the committee that would look at recent happenings emerging from the Integrity Commission, because we're looking at the review of the Act itself. But since Member Warmington, in his excellent presentation as to what we should consider, brought to light what took place a couple of weeks ago, and interestingly, Chairman, the Integrity Commission has remained silent on what took place a couple of weeks ago when a report was published which brought the Prime Minister and the country into opprobrium, as Minister Warmington indicated. And to this date, we have not had what I consider very important and appropriate apology to the Prime Minister for what took place, or even from the Integrity Commission to explain how they could allow that report to be published. To be frank with you, I read the report in and out, and most of it, the responses that were provided by the Prime Minister seemed to have neutralized anything that they said. And that is why it was clear that when it went to the Director of Corruption Proceedings, it was obvious that nothing there could be seen for a charge to be laid. But what is sad, Chairman, is that that Director of Commission's proceedings, corruption proceedings, had a ruling which was inside the Integrity Commission's offices for a month, which would have neutralized, even if it was not neutralized, but could have neutralized anything that was inside that report. and to delay it for even by 1 hour after the report was tabled gives credence to what Member Bunton is saying. You have to be careful what you publish and what you leave out. And with due respect, it has caused many persons to question whether the Integrity Commission is acting with the integrity that it should so act. Because I am worried, Chairman, very worried, that you don't know which public official, and I'm not talking about parliamentarians. There are many permanent secretaries who are very worried. There are many public officials who are very worried that complaints could be made against them. There's nothing in it, but a similar report like what appeared with Minister Bunton and the Prime Minister could be published. And believe me, that is why I repeatedly said publicly and in this committee report, we have to be very careful what we put out there. Because if it is negative, to refute it is almost impossible. And so, Chairman, I think at an appropriate time, we should insist that the Integrity Commission and the Executive Director be here to explain on what basis they could have published that report and why the ruling was not published even within 1 minute or 1 hour after it was sent to Parliament, and whether, and with due respect to the Executive Director, how he could be tweeting immediately after the report was tabled in Parliament, knowing, in my view, full well that in short order, the ruling of the Director of Corruption Proceedings has a ruling to be tabled. So these are things which they need to answer, and whether it is this committee or the Oversight Committee Chairman, we cannot let this matter lie, because I can say within the budget, 1.2 billion have been provided to the Commission, and we want to make sure that this 1.2 billion is spent appropriately, properly, and it assists in reducing corruption in this country. But when you see reports like what Member Bunton is complaining about, and the recent report involving the Prime Minister, you wonder if this is helping to reduce the impression and, indication of that we're controlling or highlighting and removing corruption. So the perception of corruption is more being widened rather than being destroyed. And that is the problem, Chairman, that reports like what Member Bunton spoke about and what came out against the Prime Minister is expanding and escalating the perception of corruption, which is not good for us.
Thank you, Member Chuck. I think Member Malahoo-Fort had a follow-up. And
thank you, Chairman. I really think that the points raised about how the work is done in the fight against corruption or to uphold integrity is critical to maintaining confidence in this important anti-corruption body. And it does no good, not institutionally.
Sorry, I'm sorry. I think you're addressing the chairman. Thank you.
Through you, Chairman. So sorry about that, Chairman. I'm saying that when you hear the concerns raised, valid concerns, the experience of persons under investigation or against whom reports have been made, there can be no disagreement on the critical need to ensure as far as possible that there is integrity in public office. And the fight against corruption is real. But when the approach is clearly questionable, it brings the institution into disrepute. And I think among the many concerns I hear, it is the one that troubles me most when the work to be done is so critical. And we speak about the need for public education on so many issues. And when we have resourced a body as well as we have resourced the Integrity Commission by way of the budget to ensure that it is fit for purpose, and the approach is one which pays greater attention to one set of activities than to others which would yield a better result. And this is not to say that any of the many activities to be undertaken, that any is insignificant. I'm saying that too many concerns have been raised about how the work is being done. And it begs the question whether the naming and shaming in the absence of sufficient information is the approach that is given precedence and priority. And the hard work that will yield result of educating the people is being relegated. It is something that we as a committee will have to look at in terms of the functions and powers, how the work is done, and in this review. So there is going to be some overlap with the work of the Oversight Committee, given the remit of it. There are areas of overlap, but what is emerging are genuine concerns about how the entity is operating, especially in recent time, and having regard to the examples cited, and for which the explanations are not plausible. So work is cut out for us.
So thank you again, Member Malahoo Fort. The member from St. Mary's Central.
Thank you very much, Chairman. Chairman, like all the submissions that have come before us, they're usually given prior to the meeting, and we usually have a time to reflect on them. This one is presented here, so we're going to need some time to really go through it. But there's just one thing I heard, and I see it in the presentation here, not the addendum, but on page 4, Member Warmington, amendment, statute declaration of members of the commission. I have no problem with the recommendation you're making, but the basis on which you're doing it, and the second paragraph said there's no question that members of the commission being members of a select committee of parliament. They aren't. They aren't. There is no question that the members of the commission being members of a select committee of parliament. No, I understand that, but I wanted him to explain, because as far as I understand, members of any committee of parliament are usually parliamentarians. Okay.
I think that the point is taken, but that's a detail, I think, which in the discussions ensuing, we certainly will be able to treat with. I just wanted to know whether there are any further reactions to the presentation that has been made, so we can in fact move on. I wanted to make the sharp distinction with Member Malahoo Fort with regards to the Oversight Committee, its responsibilities, role, and the Joint Select Committee. So the issue of the report that the Commission made, that would be the subject for the Oversight Committee, which we will have to convene to consider that report and the specific areas of it for which you, Member Chuck, has indicated the need for an apology or for any other reparatory action. So the Oversight Committee will meet, and I will convene that meeting in the interim to. Right. So we're looking at that for the Oversight Committee. In the meantime, just to remind us all that by statute, this Joint Select, its purpose is to do the full review, and I think it is appropriate that we are going to do a full review on the basis of the presentation made here today and any other submission that may come to us in the interim.
I think most of the members of this committee are also members of the...
Yes, but bear in mind this is joint select. It's
Right.
from both houses.
That's right.
Right, and the oversight is in relation to the House of Representatives.
But I was saying, Chair.
But I don't have a problem, Chairman, if when the Oversight Committee meets, that members of the Senate are invited. If that is okay, Chairman, because
We are able to do whatever.
other members of this committee...
We can invite whoever we wish to come
Right.
as observers,
I
but
think the reason for
the,
this-
the committee is a committee,
Right.
fully constituted by the standing orders.
I was saying, Chair. Well, based on what you just said a while ago, and conceivably then, the Oversight Committee could also make a submission to this particular committee then.
Well, you know, bear in mind the purpose of this Oversight Committee. As per, you know, that's why I deliberately read from the Act the powers of this committee, the provisions that enable us to act the way we are. And it is very clear that our role is specific to the review of the laws, rules, regulations which govern the whole process.
Yep,
and I think that this process is well thought through and must have been in the minds of the framers of the Act in the first instance, that because it is new, because this whole purpose has begun, and in fact Jamaica is leading the way in the Caribbean in terms of this, that there would be need for a tweaking, reviewing, amendment, changes, adjustments, as the case might be, as the Act is promulgated and is carried through and is effected. So I think that this is the appropriate time, and I know it will be read appropriately that this is a statutory requirement for the review, which has started last year and which I intend to conclude by the 31st of May.
Mr. Chairman, I just wanted to say, even though there is another committee, Oversight Committee, the fact is that this committee that is reviewing the legislation must review it in light of the experience of the operation of the committee. So I don't think there is anything outside the scope of this committee to have to be able to interrogate the way that the Integrity Commission has operated in the period since the initial passage of the Act.
So I will take guidance on that simply because the provision for the report to be presented to the Oversight Committee, bearing in mind that the Joint Select was constructed for a specific purpose as per the Act. So I'll be guided, and I will seek the clerk's support in enabling a full interpretation of the standing orders in that regard.
My recollection, Chairman, is that we had put today and next week for this committee to meet.
Yes, 29.
Right. I would ask that we use the 29th for the Oversight Committee to meet instead, where we also invite other members of this body to be there, so we can look not only at recent happenings, but generally as to how the body has been operating, which, as Member Bunton has said, will guide us.
Which is really the purpose
Exactly.
for
so
which we meet.
I would say we
Yes.
don't cancel next week's meeting. We use it for the Oversight Committee because I think my colleagues wanted some more time to consider before we get into further discussion. Right.
Right. So that the purpose of the Oversight Committee, which is being suggested, and of course that will be subjected to the members of the Oversight Committee agreeing as per the practice.
Chairman, most of us are here of that Oversight
No,
Committee.
no, but
Yeah.
separate and apart. I don't think it's the remit of this Joint Select to
Right,
go
but-
there.
but the truth
Let
of-
me, as chair, do what we normally do, and I assure you we will have a meeting on the 29th.
Right, and I think, since the country at large had been asking for the Integrity Commission to explain itself, next Wednesday, let them get a chance to explain themselves.
Please, member. The chair is the chair. Thank you. Yes.
And so, Chair, at that meeting next week, whatever form it takes, the Attorney General the Chambers will have a representative we could ask.
You are not asking me for a response at this committee, since this committee really cannot.
Well, I don't know which committee is meeting next week.
So I heard you.
So
wearing another hat, I hear you.
Okay, no problem.
Thank you, members. I think we had a very fulsome discussion, and I think we have a direction as to how we proceed to conclude the first. And I think it is important because the nation needs to appreciate that this constitutional arrangement is always there to protect, to ensure the rights of the citizens, to ensure that all our undertakings are always to inure to the strengthening of our democracy and the sustenance of the rights of the individuals within the society. So I thank you very much. Any other matter? Any other business? This meeting is adjourned, and for a date to be fixed, because we could meet in the interim between now and the 29th of April. Okay, very well.